you definitely should have a trust if you have property in more than one state. And here's why. Believe it or not, if you pass away, and I have this situation occur with a lot of people here. I mean, they own houses in Arizona, Idaho, Florida. Well, what happens to that property if you pass away here in California? Well, guess what? You have to open up what they call an ancillary probate in Arizona or Idaho or wherever that piece of property is. So now you're running two probates at the same time. Whereas if you have a trust-based plan here in California to handle your estate and you own the vacation home in Florida or in Arizona, all we do is we contact an attorney in Florida or Arizona, wherever, and we say, okay, we've set up this trust. We send them a copy of the certificate of trust that I provide my clients. And that, again, tells them what the vesting should be for that piece of property. They simply make out a new deed for the property in Florida or Arizona, record it with their county recorder in that state, and guess what? It's in the box. It's that simple. Well, here's the deal financially. Just like I said, probate costs are about 5% of the gross value of the estate in California. That also runs true in a lot of other states. And again, I don't speak to the specific probate fees in each of these states because I'm not licensed there, but I will tell you as a general rule, they're pretty close to about the same. So if you've got, the $500,000 condo in Florida that you go to every once in a while with your family, rest assured, if you're going to run an ancillary probate, you're probably going to spend $20,000 or $25,000 putting that into your estate plan if you haven't already done it through a trust-based plan. You'll be paying probate fees in both states. And I've had this happen. I'm dealing with a client that brother passed away in Las Vegas, didn't have any estate plan. He had property here, so I'm handling the San Diego probate, and I'm dealing with a lawyer in Las Vegas for the asset over there. So yeah, the client he's incurring fees with me as I'm coordinating with the lawyer in Arizona. So in that sense, and there's no way around it. And had the brother had, a proper estate plan, it's all avoidable. So again, from dealing the aspect of an out-of-state piece of property, even though let's say you have a piece of property in Nevada and a piece of property here in California, obviously the lawyer who's dealing with the property in Nevada is getting paid out of that probate. The lawyer who deals with the property in California is getting paid out of the California probate. But to a certain extent, the lawyers are communicating with each other to coordinate the handling of both of these estates. And so the estate is getting charged additional money for those lawyers, and it's a necessary evil. I mean, there's no way around it. So having a trust-based plan and doing away with the ancillary probate not only eliminates the other probate fees, it eliminates what is otherwise perhaps duplicative efforts being spent by two different lawyers. So again, if you own property in more than one state, to avoid the possibility of what we know as an ancillary probate, having a proper California-based plan is important. So there's a link down at the bottom where you can contact me, discuss a situation so that it doesn't happen to you and your family.